welcome to this presentation on prosecutor ethics. Before I begin, I would like to acknowledge the traditional owners and custodians of this land. I would also like to pay my respects to elders past, present and emerging. So what is prosecutor ethics? Prosecutor ethics encompasses the ethical standards that are expected of prosecutors. This includes the requirements for prosecutors to seek to protect the innocent and convict the guilty, consider the interests of victims and witnesses, and respect the constitutional and legal rights of all persons, including suspects and defendants. Two key aspects of the prosecutor's role is to uphold standards of fairness and disclose all relevant material. A number of ethical challenges that prosecutors face will often arise in child sexual abuse cases. Child sexual assault cases are notoriously hard to prosecute. This is for a number of reasons. Firstly, there are low rates of reporting. Secondly, there's a lack of evidence. Usually, the child's testimony is the only available evidence. Thirdly, there is often a lack of credibility. Jurors often tend to view children as unreliable witnesses, and this is further exacerbated when children change or recant part of their testimony. Finally, children may be further traumatized by going through a trial and facing cross-examination. These issues have led to low rates of convictions for child sexual abuse cases, with a high proportion of defendants that are charged with these offences ultimately having their charges dismissed. To demonstrate some of these issues in practice, this presentation will discuss a factual scenario. This factual scenario contains three key ethical dilemmas that prosecutors may face. Each of these will be considered in turn, and the legal principles that underpin these issues will be shared. Finally, we will consider a well-known model for ethical decision-making called the Rest-Beakley model. This is the first part of the scenario. Joanna is a solicitor working for the Australian Federal Prosecution Service. She has been approached by her colleague to take on a particularly egregious case involving a child who has allegedly been sexually abused. Joanna is hesitant in approaching this case, as her younger brother has experienced sexual abuse as a child. She can recall how painful it was to go through that event only to have the accused person escape any charges. Upon assessing the case, Joanna is also becoming increasingly concerned that the victim may not be a reliable source. While she believes the child, the only evidence for this case is the child's testimony. The child also originally denied the events took place. This brings us to the first ethical issue, which is, should Joanna advise that the accused should be prosecuted? Here, the key ethical dilemma is a conflict between the desire to protect the child and prosecute the accused, and the rules that Joanna must abide by. These rules include Rule 21.1 of the Solicitor's Conduct Rules. This rule states, a solicitor must take care to ensure that the solicitor's advice to invoke the coercive powers of a court is reasonably justified by the material then available to the solicitor, is appropriate for the robust advancement of the client's case on its merits, is not made principally in order to harass or embarrass a person, and is not made principally in order to gain some collateral advantage for the client or the solicitor or the instructing solicitor out of court. At the time the case is brought to Joanna, the only available evidence is the testimony of the child. This is arguably not enough material to justify invoking the powers of the court. Additionally, Joanna's motivation for advising that the accused should be prosecuted are arguably influenced by Joanna's own experience with child sexual assault. This means she may also be breaching her duty to not invoke the powers of the court to gain an advantage. Finally, Joanna's actions are also in conflict with her paramount duty to the court, as she is bringing a case without sufficient evidence and therefore is wasting the court's time. The conflict Joanna is facing in this part of the scenario is also clearly depicted in Wendell's bridge between ordinary morality and professional ethics. On one side of this bridge is the rules that guide legal practice, and on the other is societal expectations. A simple exercise can be conducted to demonstrate how this metaphorical bridge exists in real life. On the left is Ben. He's a consultant in the construction industry, and on the right is Carla, a final year law student currently studying ethics. Carla and Ben both read the first part of the fact scenario, and their answers to the question of whether Joanna should advise on prosecution were different. Ben said yes, as he believes that if a child reports something like this, it should be investigated and prosecuted to ensure that it does not happen to another child. Carla said no, as she didn't believe there was enough evidence at this stage. The difference in these answers shows where both Carla and Ben sit on the bridge as a result of their professional background and demonstrates the interplay between professional ethics and ordinary morality. In making her decision, Joanna must also consider where on the bridge she should sit. This brings us to part 2 of the scenario, where Joanna has ultimately decided that she will advise that the accused should be prosecuted. She believes the child is telling the truth and is very concerned the person accused may escape charges. She schedules a meeting with the family and decides to talk one-on-one with the child. She quickly establishes a relationship with them. Whilst talking to the child, Joanna attempts to confirm the child's testimony. On doing this, the child reveals to her that a part of the testimony is not true and proceeds to recant a portion. Joanna then takes a break from confirming the testimony under the impression the child is lying about their testimony not being true. Later, Joanna continues talking to the child and asks if the child lied about their testimony not being true because they were afraid of getting someone in trouble. After a pause, the child answers yes. Joanna believes the child is telling the truth and sees no need to reveal that the child attempted to recant their testimony to the accused's defence team. The second ethical issue is, should Joanna have told the defence barrister about the child attempting to recant part of their testimony? Here, Joanna's desire to protect the child, ensure they come across as a reliable witness, and ultimately win the case comes into conflict with a professional obligation to disclose material evidence. The key rules here are 29.5 and 29.6 of the Australian Solicitors Conduct Rules. Rule 29.5 states, a prosecutor must disclose to the opponent as soon as practicable all material available to the prosecutor or of which the prosecutor becomes aware which would constitute evidence relevant to the guilt or innocence of the accused, other than material subject to statutory immunity, unless the prosecutor believes on reasonable grounds that such disclosure or full disclosure would seriously threaten the integrity of the administration of justice in those proceedings or the safety of any person. And 29.6, which is relevant for when a prosecutor decides not to disclose material, states, a prosecutor who has decided not to disclose material to the opponent under Rule 29.5 must consider whether the charge against the accused to which such material is relevant should be withdrawn, or the accused should be faced only with a lesser charge to which such material would not be so relevant. When we apply these rules to the fact scenario, we see that Joanna has breached them. Joanna has not disclosed the fact that the child recanted part of their testimony. Recanting a portion of testimony is of significant relevance to the conviction of the accused in this case, as the child's testimony is the only decisive evidence for this case. Additionally, there was no evidence to suggest the evidence should not have been disclosed to ensure the administration of justice or to protect the safety of someone. These are the only two exceptions provided under Rule 29.5. Hence, the decision of not disclosing the evidence to the defence barrister indicates that Joanna failed to properly consider Rule 29.5 and subsequently breached the duty to disclose evidence. Additionally, upon deciding not to disclose the information, Joanna should have considered Rule 29.6 and decided whether the charge against the accused should have been withdrawn or whether a lesser charge should have been brought. She did not do this, so Joanna also breached Rule 29.6. Finally, this issue demonstrates the ethical blind spot. Due to Joanna's desire to protect the child and win the case, she has turned a blind eye on her legal obligations. This brings us to the final part of the scenario. Joanna becomes determined to put away the accused person, and when the trial begins, she attacks the accused character through calling him disgusting, with grotesque and out-of-control impulses. She also decides to appeal to the jurors' feelings by asking them questions like, how would you feel if someone did this to your child, or your little brother or sister? The final ethical issue is advise Joanna on the possible consequences of this behaviour during the hearing. Here, the ethical dilemma is Joanna's own personal bias coming into conflict with the accused's right to a fair trial. When considering the relevant legal principles in this area, it becomes clear that prosecuting counsel in a criminal trial represents the state, and prosecutors should act always with the objectives of establishing the whole truth in accordance with the procedures and standards. Relevant rules in this area include Rule 29.1, which states, a prosecutor must fairly assist the court to arrive at the truth, must seek impartially to have the whole of the relevant evidence placed intelligibly before the court, and must seek to assist the court with adequate submissions of law to enable the law properly to be applied to the facts. Rule 29.3 is also relevant, which states, a prosecutor must not, by language or other conduct, seek to inflame or bias the court against the accused. Here, Joanna's comments are inflammatory, and her questions are non-neutral and appeal to the feelings of the jury. Her conduct through using comments such as disgusting and grotesque are breaches of Rule 29.3, as it is language that has the potential to bias the court against the accused. Additionally, Joanna has breached Rule 29.1 as her personal bias has gotten in the way of assisting the court to arrive at the truth. Now, it is important to consider what the outcomes of these numerous breaches may be. Due to Joanna's failure to comply with her legal and ethical obligations, it is likely that the defendant in this case would either be acquitted or a new trial would be ordered. She personally would also likely face serious consequences for her numerous breaches and may even get struck off the roll. A key way for prosecutors and all legal professionals to prevent incidents like this from happening is through using an ethical decision-making framework to guide their decisions. One of these models is the Breast-Beakley model. This model is a theoretical model that assists in analysing ethical decision-making. The model has 6 stages. Number 1 is awareness, which requires realising the ethical dimensions of a situation. Number 2 is judgment, which requires making a correct judgment about what morality requires of you. Number 3 is decision-making. Here, you must be motivated to make a choice and act on the judgment. Moral motives must impel you to prioritise the demands of ethics in the face of other desires, such as self-interests and pressures. Number 4 is action. You must act and follow through on your decision. Number 5 is achievement. You must successfully implement your ethical decision and achieve your goal. Number 6 is review, which requires you to evaluate your ethical action and reflect upon the results. If Joanna had considered this model when making her ethical decisions, she may not have chosen the actions that breached her duties and subsequently would not face the potential consequences. That brings this presentation to a close, and thank you for watching.